judge presiding. All persons having business before this court drawn near, give attention, you will be heard. May God save the United States of America, the state of Florida, this honorable court. Please be seated.
Good morning. Welcome to an oral argument session of the 5th District Court of Appeal. I've already been introduced by our Marshal, Aaron Soltz. Thank you, Marshal Soltz. Joining me on this panel today, to my right and your left, is Judge John Harris from Brevard County, and to my left and your right, Judge Joe Boatwright from Putnam County. I'm from Seminole County. Please, before we start the oral arguments, make sure that you've silenced any devices that may unexpectedly make noise. Either turn them off or just put them on mute so it doesn't disrupt the lawyers in their presentation. And I will assume for both appellants, unless you tell me otherwise, that you would like 5 minutes for rebuttal. So please correct me, and I will adjust the clock, or Marshal Soltz will adjust the clock. The first case that we have on the docket is KG, a child by and through Vicky Benoris as parent legal guardian versus Florida Insurance Guarantee Association. And whenever the appellant is ready, you may begin.
Thank you, Your Honor. May it please the Court?
Yes, good morning.
Ben Hasselbrock on behalf of KG, the appellant in this matter. We are here today because this Court's prior decision in Premier v. Adams and 20 years later in Halen v. Gulfstream mandate reversal of the trial court's order dismissing KG's cause of action in this case. We are dealing with the application of a severability clause in an insurance policy. And in 1994, this court ruled on that issue in Premier v. Adams and held that the severability clause means that each insured should be treated as having separate coverage. And that's exactly what happened in that case, where it was applied to an expected or intended conduct exclusion, expected or intended by any insured. And the court said this exclusion operates to defeat coverage for the son who committed the intentional conduct in that case, which was an alleged sexual battery, but it does not operate to defeat coverage for the parents who acted negligently, because the severability clause requires a separate analysis for each insured.
Doesn't the severability clause deal with who's being sued versus here the exception depends on who actually owned the motor vehicle? Isn't that a distinction here?
Well, I don't believe so, Your Honor. It is the distinction that was drawn by the trial court, but that's not consistent with the case law. So when you move beyond Premier v. Adams in 94, you come to the Halen case, which I believe was Judge Wallace wrote the decision in 2014, 20 years later. Same result, essentially the same language there. But when you move to the 6 other cases that have decided this issue, in between and after the Premier and Halen decisions, you have no distinction based on the type of insurance policy or the type of exclusion.
Well, you're arguing that it's ambiguous, correct? There's a motor vehicle exception and there's a severability, and you're arguing that it's ambiguous based on the precedent in the Adams case, correct?
Correct, Your Honor.
So what is ambiguous about the recreational use exception? I mean, it says it does not apply if the motor vehicle is owned, and I think the key word is an insured. And was the motor vehicle or the ATV owned by one of the insured or an insured? The mother, correct?
Yes, the mother, correct. Okay,
so why does that exclusion not apply? Why do we even need to go to the severability clause?
Well, because you have to read the policy as a whole. And so that's what all these courts have said, is that, and this court has said, when you look at the severability clause and it says, we're going to apply this insurance, it applies separately to each insured. What does that mean? What can it mean other than we look at the coverage analysis independently for each of these insureds? And that's been consistent throughout this line of cases, both from the 2 cases that I cited from this district, but these 6 other cases.
Most factually similar case would be Aiello, right?
No, Your Honor. I think the most factually similar case would be Giovera Specialty versus House. It was a 2009 decision from the Southern District of Florida, but that involved an ATV, a motor vehicle exclusion, and the ownership issue was the issue there. And the exact result that we asked the court to reach here is the result that was reached in that case. They found the ambiguity, they applied the severability clause, and they said for the owner of that ATV, the exclusion applies. For the parents, it does not, because they are not owners of the vehicle, and we analyze that coverage independently for each of these insureds.
So what you're asking us to do is basically, I believe, get virtually no effect to any limitation on the ownership of the ATV as it applies to the minor. Is that correct?
I'm not sure if I'm not sure I
We're
understand.
supposed to give effect to any wording in the entire policy, correct, as it is written. If there's any ambiguity, it's supposed to be drawn an inference for coverage and not against coverage. But I think what you're asking us to do is basically not apply the requirement of ownership as it applies to the minor who is operating the ATV. That's the effect that you're telling us by saying, listen, ownership, I believe what you're saying is ownership in this specific limited factual situation is irrelevant.
Well, it isn't irrelevant because the exclusion still applies to the owner, exactly as it should. So the exclusion is not being written out of the policy in any way. It's the insurer that's asking to rewrite the coverage by saying, don't look over here at our severability clause.
Well, but if the tortfeasor was the mother and not the minor, then the exclusion would apply to the parent, correct? I mean,
Correct.
there would be no dispute. It would be clearly unambiguous. You would agree?
Correct. If the exclusion operates against the owner of the vehicle. So if the mother was the tortfeasor and owned the vehicle, then the exclusion would operate and she would have no coverage. And that's consistent with what we're asking the court here. We're not asking the court to change the result with respect to the mother of the vehicle who's clearly excluded. We're asking the court to interpret the severability clause and apply it the way it has consistently with other cases and say, we're going to look at each insured. And for the non-owner of the vehicle, just as the result was in Giovera Specialty
So
versus
you're
House.
saying KG is the insured, but as the trial court pointed out, the policy says an insured. So that that seems to be the distinction here. I mean, how do you differentiate that?
Well, because again, in the case law, they have looked at all formulations of this. So there has been a the insured case, there has been an insured case, there has been an any insured case. And in all of those cases, the severability clause analysis is applied exactly the same because it doesn't change the way the severability clause operates to say we look at each insured independently. So that's exactly, Premier versus Adams was the case involving the language any insured. Well, of course, any insured is going to mean any of the insureds, potentially all of the insureds that are covered under the policy. But this court said, no, that's not the way we look at it. The severability clause means we take each insured individually. And so we have, 3 insureds, a child and 2 parents that are being sued. And so we look at them individually as if they don't have their own separate coverage. And so in that case, in Premier versus Adams, where we're talking about intentional conduct, the exclusion operates exactly as it's written and exactly as it should for the individual who committed the intentional conduct, in that case, the son. For the parents who did not, when we apply that severability clause analysis and look at them independently, then that exclusion, which says any insured, does not apply. Because when we look at them individually, any insured only means the separate individual under the severability analysis. And that's, again, consistent not only with the Premier versus Adams case and the Halen versus Gulfstream case, but these 6 other cases where it's been applied in homeowners insurance, auto insurance, commercial general liability insurance. It's been applied to intentional act exclusions. It's been applied
What about the case Judge Harris mentioned with the watercraft exclusion? That's different, correct?
ILO, correct. And I absolutely want to talk about the ILO decision. But these other 6 cases that have applied it in even other contexts, like the other insurance clause, where, and this was an ownership of a vehicle situation, to determine whether a policy is excess over other insurance. I believe that was the Comcar decision. And also to the motor vehicle liability exclusion that we're talking about here, which was the Giovera Specialty versus House case. So turning to ILO, This is a 4th District decision from 2021, and I think it's clear that under all of this precedent that exists out there, it was wrongly decided. But the court was motivated by 2 specific issues that I wanted to address. So first is this false distinction between ownership and conduct. That came from the Aiello case. It doesn't appear in any other cases, and in fact, in several of these decisions, these 8 cases that we've talked about, there are issues besides intentional conduct that were the motivating factor in those decisions. So when you're talking about the employer liability cases, that turned on the status of an employee-employer relationship. Those cases did not involve any sort of intentional conduct. And the same thing with the ownership issue of a motor vehicle. We have the Giovera Specialty versus House case, and we also have the Comcar Industries case, which was a 2008 Middle District of Florida case that decided an auto policy was excess precisely on the ownership issue and the severability clause analysis. And so that distinction that Aiello drew is not applied in any of these 8 cases, any of these other 8 cases. The second issue from Aiello that is important that I think is important to understand and distinguish is the court incorrectly considered the reasonable expectations of the homeowner's policy or homeowner's coverage and what it's designed to do. And the Florida Supreme Court and Florida law generally has rejected the idea that we're going to look at anything other than the policy language to determine the reasonable expectations of the parties and what the policy means. And so if you look at the last paragraph of Aiello, the court justifies its decision by saying, well, this is a reasonable scheme that we would assume that this is the nature of the risk that the insurer intended to accept. But that's not the analysis that any of these other courts have engaged in, and the Florida Supreme Court says that's not the correct or appropriate analysis under Florida law. And so we go back to Premier versus Adams, we go back to Halen, we go back to the 6 cases that follow suit. There's no distinction between ownership and conduct found in any of those cases. And there's no discussion of reasonable expectations because the courts are doing precisely what Florida law requires and looking at the policy language and saying, okay, we have this severability clause. What can it mean other than, what's it doing here? You know, there's nothing in Florida law that requires the insurer to put that provision in their policy. So we have to give it force and effect. And so what does it mean other than to treat each insured separately? And I believe that's part of the motivation of these cases. I mean, I don't recall if it was Adams specifically that held this, but the severability clause would be illusory. It would have no meaning. In one case, Judge Wallace, you asked, well, am I asking the court to just eliminate this exclusion? We're not. We're asking it to be limited to the way it's written when you apply the severability analysis and only apply that exclusion to the ownership issue. But if you go the other direction and say, well, we're going to apply any insured, what is the meaning of the severability clause? What function does it have in the policy? It would be completely illusory. And that's what has motivated at least some of these courts in these other 8 decisions to say, we have to give it effect, and this is the only effect it can have. In addition, there are several cases that show that this is completely within the insurer's capacity to control. They can use anti-severability language. They can use different language in their policy to get the result that they want, if that's what they intend. And there are a handful of cases where exclusions have been written, you know, an absolute exclusion that doesn't turn on an ownership issue. It's just an absolute motor vehicle liability exclusion. That takes the ownership question out of it. Now we're not talking about what does severability do. Or more specifically, to write an exclusion.
How would you rewrite the exclusion to clearly give cause and effect to the factual situation in this case that would take into account both the severability and the ownership requirement? What would be the wording that you would use to write that exclusion?
So I believe I would use the language that was used in these 4 other decisions where they just...
Which decision? Which one?
Sorry, there's a AIX specialty decision, 2 AIX specialty decisions, Ashland 2, which is a Middle District of Florida, 2019, and AIX specialty versus Sombreros, which is Middle District of Florida, 2018. And then there are 2 Burlington insurance decisions, Burlington versus Normandy, 11th Circuit 2014, and Burlington versus McGahee, Northern District of Florida 2023. And in those cases, the language was that the exclusion at issue shall not be subject to any severability or separation of insured provision in the policy. And that is the answer. You can just eliminate it. You can say, when you read this exclusion, we're not talking about severability. We don't want the severability aspect of our policy to apply to this particular exclusion.
Your position is that drafting the clause that way would bring about the same effect that the trial judge ruled in this case, which is no coverage or an exclusion of coverage. Is that correct?
Certainly, Honor. This is a scenario where we are talking about the policy language and relying on the policy language. And insurer has chosen to include the language of the severability clause. If they want to eliminate that severability clause from the policy entirely, or if they want to eliminate it from certain exclusions or certain provisions of the policy, I believe that contractually they can write that language and do it. And that is what happened in these 4 cases. So they have control over this. They know this law exists. As I said, Judge Wallace, I believe you wrote the decision in Halen, and I believe that my colleague here was a part of presenting that case on behalf of the insurer. They know this law is out there. If they want to control for this result, and if they intend not to cover this scenario, not to provide no coverage to any insured in this scenario, they have the capacity to write that language. And these other cases demonstrate that they can simply say, the severability clause is not going to apply to this particular exclusion or to this particular provision of the policy. And if they don't say that again, and the court simply makes the ruling that we're not going to look at the severability clause, we're just going to apply this exclusion, then what does it mean and why is it there? And how are we giving credence to the Florida law that says we have to read the policy as a whole, and where other provisions of the policy are applied to create an inconsistency or an ambiguity, then we have to sort it out. And ultimately, if there is inconsistency or ambiguity based on those provisions, we have to resolve that in favor of coverage. That is what we ask the court here. And I see that I am over my reserved time, so thank you very much.
Thank you.
Good morning, Hinda Klein here on behalf of FIGA. I think this case can be summed up by citing the standard rule of interpretation, which is that only when there is more than one reasonable interpretation is policy language truly ambiguous. That's not the case here. What opposing counsel is arguing is that you should read these 2 provisions of the policy without regard to whether or not they are truly ambiguous, and without regard to whether their interpretation makes any sense at all. And we submit that it does not. We believe that Aiello is the case that this court should follow. And it is certainly the case that is most like this case. And in that case, there was a watercraft exclusion for watercrafts owned by an insured. And, of course, there was a severability clause.
How did the 4th District in Aiello distinguish Adams?
It distinguished Adams because Adams, as well as Halen, actually, was an intentional act exclusion case, and it made perfect sense to exclude the intentional actor without prejudicing those who were not intentionally at fault. That's not the case we have here. We have a case where the exclusion excludes coverage for accidents arising out of an ATV that is owned by an insured, and it makes perfect sense because the homeowner's carrier is not a motor vehicle carrier, and that's why the exclusion is there. And that's precisely why the exclusion should apply to all insureds regardless of the severability clause. And I think the Aiello case really clearly reasoned that you have to look at the big picture. You have to look at the purpose of the policy and the purpose of the exclusion. You can't simply ignore those and apply the severability clause without taking that into consideration, because the ultimate question is, are there two reasonable interpretations? And we submit that the interpretation that is urged in this case is simply unreasonable. As I mentioned, this court's case law in the Adams case and the Halen case are both distinguishable in that the exclusion at issue was for an intentional act. And it made perfect sense to apply the severability provision in that case, because you don't want to provide intentional act insurance as a matter of public policy, but it is unfair to apply that when the only claim that is made against an insured is for simple negligence. Here, of course, we don't have that issue. And I would point out also that this court, I think, did recognize that distinction in the Adams case. Towards the end, the policy contains an exclusion for intentional acts of any insured and contains a severability clause creating a separate insurable interest in each individual insured in accordance with the rules of construction of a contract. The most plausible interpretation is that the exclusionary clause is to exclude coverage for the separate insurable interest of that insured who intentionally causes the injury. With this interpretation, all provisions in the policy are given meaning, and one provision is not rendered meaningless by the other. So this court did take into account the kind of exclusion, the public policy against it, the reason why it was in the policy, and decided that the most plausible interpretation was that the severability clause would apply in that instance.
Klein, what was the intent in drafting the policy to require the ownership or lack of ownership requirement for the owner of the ATV?
I believe that the reason for that exclusion was to make sure that this did not turn into a motor vehicle liability policy. This is a homeowner's policy, and it makes absolute sense that it would exclude coverage for claims arising out of the use of a motor vehicle, in this case an ATV. And so for that reason, you want applying a severability clause in that instance would make absolutely no sense, because it would turn it into a motor vehicle liability clause to some insureds and not to others, which is precisely what the Aiello case reasoned.
Wouldn't that, and when you're dealing with a minor who's operating a ATV or a non-street legal piece of machinery, you're automatically then going to exclude the minor from any responsibility, and or the parent from any responsibility for operation of that, just purely because the minor is incapable of actually owning the vehicle, correct?
Correct. That's correct. That would be.
So isn't that across the board shield for the insureds, the parents in this case, to just go ahead, you can let anyone, regardless of age, operate this vehicle. There will be no coverage because we own it. And wouldn't that insulate them from exercising any reasonable care in cutting loose, whether it's their children or other children, on arguably machinery they shouldn't be operating?
Well, that involves a liability determination, not an insurance policy determination. Certainly,
but isn't
they
the
can be held
homeowner's insurance insuring that against that precisely? Homeowners insurance is protecting the insureds against that liability, negligence, correct?
I'm not sure I follow, Your Honor. I think what Your Honor is asking is a liability question. If there's no coverage for injuries arising out of the use of an ATV, it's because this is not a motor vehicle policy. It is that the claim could be covered by a different kind of a policy, which I guess presumably the insureds in this case did not have. But regardless of whether it's covered under this policy, certainly the plaintiff in this case can pursue whatever action she wants to sue against both the minor and the parents without regard to insurance. The question before the court is whether or not there's insurance coverage under this policy and not whether or not the parents or the minor can be held civilly liable for the claim in this case. We submit that this court should follow the reasoning in the Aiello case. It is indistinguishable from the facts in this case. And the Adams and the Halen case, on which opposing counsel heavily relies, are distinguishable in that they involve an intentional act exclusion, and there is a rational reason for distinguishing between the intentional actor and the simply negligent actor. And in that case, the interpretation urged by the insureds was reasonable. The interpretation urged by the insured in this case is simply not. And since there is no more than one reasonable interpretation, that means there is no true ambiguity in this policy, and it should be implied as written. If there are no further questions, I'll rest on my brief. Thank you.
Thank you. Counsel, you have a little short of 4.5 minutes.
Thank you, Your Honor. So I wanted to return to the intent issue for just a moment because, as I said earlier, I believe the only thing we are looking at to determine intent here, the only thing we should be looking at is the policy language itself. But when you asked counsel about what is the intent, and the answer was to not turn this into a motor vehicle policy, I think it's important to recognize that they accepted some motor vehicle liability. The insurer could have written a homeowner's policy with an absolute motor vehicle exclusion, and they didn't do that. They decided to write a limited motor vehicle exclusion and partly turned on the ownership of the vehicle. That is why we are here. So it isn't correct to say that we intended for this homeowner's policy to cover no motor vehicle liability, because that isn't what they wrote. We have an exclusion, and our position is enforce the exclusion as to the ownership of the vehicle and enforce the severability clause so that those non-owners obtain coverage, which is exactly what all these other cases have consistently said. And to submit that it's not unreasonable, or that KG's interpretation is not a reasonable interpretation, well, clearly Judge Martinez would disagree, because he wrote the opinion in Giovera Specialty versus House, where that was the exact issue, a motor vehicle exclusion, an ownership issue, and came to the exact result that we are advancing before this court. And the trial court here did not discuss any of these decisions in the dismissal order. The only case that's mentioned there is Aiello. It doesn't discuss the controlling precedent from this court, Premier versus Adams or Halen versus Gulfstream, or any of the other decisions. There was no hearing on these motions in the lower court. We got a dismissal order that cites Aiello and Aiello only, which is a 4th District decision that doesn't control the outcome here. But I want to take one step back, because this actually goes back, our analysis and this severability clause analysis goes back to the Florida Supreme Court. The 4th District decided the Skoidema case back in 1966, which changed the outcome. The law in Florida had been different before that, and applied this severability clause analysis, and that case was approved, that decision was approved by the Florida Supreme Court. And in Adams, this court relied on a Massachusetts Supreme Court decision, Marnell. And that Massachusetts Supreme Court decision was a motor vehicle liability case, a motor vehicle exclusion. And the son owned and operated the vehicle and was excluded. And so the parents, under the severability clause analysis, who did not own and operate the vehicle were not excluded. So even this court's decision recognized and followed another court having this same analysis for a motor vehicle and an ownership issue and did not draw any distinction between ownership and conduct. And the concern here is that if this court were to uphold the trial court's order, it's effectively abandoning Premier versus Adams. The only alternative is to navigate around it in a situation where this severability clause is going to be applied one way to some form of exclusions and another way to some other form of exclusions. And that is not a scenario that is going to be palatable for the courts of the state in terms of creating uniformity for insurers especially, who can, again, contract around this result if they want to, and creating litigation, because now we're going to have a question about every exclusion that is written with some language about ownership or status of an employee versus the severability clause and how it should be applied. And courts are going to have a myriad of results around that. So ultimately, Premier versus Adams is the correct rule. It has been the law since 1994. It was upheld 20 years later. And it's the rule that should be applied consistently in this case to reach the same result. And so we ask this court to apply its precedent from Adams and Halen decisions and reverse the trial court's decision below.
Thank you.
Thank you.